Hi, I'm Sam Kemble with Workforce Delivery Inc. Welcome to part 2 of our accommodation of medical marijuana series within the context of a safety sensitive environment. We've been speaking about a case involving Brandon Uprichard, and who was represented by Local 1620 of the IBW, and the employer was represented by the Lower Churchill Transmission Construction Employers Association. Now, there's a lot of water under the bridge by the time we get to the point that we're talking about today, that being a termination, original arbitration, a court appeal of that arbitration, and then that court sending a portion of the decision back to the original arbitrator for additional clarification. So for those that are just joining us, I'll just kind of briefly touch on the fact set. Brandon Uprichard was terminated on August 24th, 2015 for violating an alcohol and drug work rule. Prior to that, in 2014, the griever had obtained a prescription for medicinal marijuana and was using said medication, and that was for back pain, chronic back pain and anxiety. The griever was working in a safety-sensitive environment and expressed in a very deliberate way, concealed the fact that he had medicinal marijuana on his person or on and around the project, and also concealed the fact that he had a prescription for medicinal marijuana and was using said prescription. So, as part of the griever's job, he was on a safety-sensitive position, safety-sensitive work site, and he was also operating equipment. Pursuant to Canada Health guidelines, individuals are not to operate equipment for a period of 24 hours following ingesting medicinal marijuana. Now, this was a slight change from the original instructions the griever would have received in 2014 from his physician, which stated that driving and operating equipment was not to occur for a period of 4 hours following the ingesting of medicinal marijuana. So that added a slight twist in this case, but the health guidelines are in fact 24 hours that individuals are not supposed to be driving or operating equipment following ingestion of medicinal marijuana. So, in terms of how this individual was identified to the employer, given that he concealed the fact that he had marijuana in his possession and concealed the fact that he had a prescription that he was actively engaged in, it actually turned out that a safety advisor confronted the griever and 3 of his co-workers while they were in a pickup truck that was transporting the crew from the camp into the job site. And the safety advisor confronted all the participants in the vehicle because the safety advisor could smell marijuana emanating from the vehicle itself. And the safety advisor asked the crew if they were smoking marijuana. And in response to that, the griever had said that he had a prescription for medical marijuana, and that then he produced a copy of his prescription for the safety advisor's review. So this apparently must have thrown the safety advisor and his employer off, because, and I use this picture because I seriously don't understand what kind of Jedi mind trick this individual was playing here, but it seems to be partially effective, because both him and the 3 co-workers in the truck were not asked to submit to an alcohol and drug test. And the policy that they were operating under did have reasonable cause or reasonable suspicion testing provisions. In addition, the griever himself was sent back to work in a safety-sensitive position on that day, and then for 4 subsequent shifts thereafter, before the employer terminated him for cause for violating the safety-based, safety-purposed alcohol and drug work rule. So that was a really strange and unfortunate part of this fact set. Very distracting, and it could have thrown the arbitrator off the trail, so to speak, of what was really going on here. So highly advisable that that's not how an employer should respond. Obviously, Ballard Construction was caught off guard by this medicinal marijuana case and didn't really know how to respond, but hopefully they've learned since. In regards to the allegations that the employer relied upon in their initial termination, reasons for termination for the griever was four parts. One is they alleged that there was smoking while on the project property, or ingestion of marijuana while on project property, that the individual was impaired while working or on project property, that the individual was in possession of marijuana, a prohibited substance, while on project property, and failed to disclose that he had a prescription for medicinal marijuana. Now, the only two, because there was no A&D test, the only two that were actually substantiated or accepted by the arbitration and the courts was simply that he had possession of marijuana and that he failed to disclose that he was had a prescription for medicinal marijuana. Now, in regards to the failure to disclose, there are two work rules in place that address this. One was the Canadian Model Alcohol and Drug Work Rule, and the other was the Project Safety Handbook Guidelines. And in regards to the Canadian model, the way it operates is if someone is on a prescription, it kind of works in the reverse. In the first instance, they are in violation of the Canadian Alcohol and Drug Work Rule, and only if the individual is taking the medication in accordance with the physician's instructions or the manufacturer's instructions in the case of over-the-counter medication, and B, doing so does not affect the person's ability to work safely, or if it does affect the person's ability to work safely, the individual informs his manager or supervisors and company of that fact and of any side effects prior to engaging in any safety-sensitive duties. So that is the path to maintaining compliance with the Alcohol and Drug Work Rule under the Canadian model. And then in regards to the project, reduces that to, I guess, a more concise but not quite as an elaborate statement, simply that employees must report all medications that they are taking, including over-the-counter medications, prior to engaging in work. So the griever had both of those standards applied to him, and he violated both of them by refusing to disclose the medication. So in terms of the griever and the seriousness of failing to disclose that the person was taking that medication, the Employers Association brought in experts to describe what impact this has or could have. The expert testified that individuals have visible signs of impairment if there's 2 nanograms per milliliter in the system, and under that threshold, there's visible signs of impairment. And also, if extrapolated, if you will, that if the griever was actually taking his prescribed amount, which was the 2 grams per day, after shift in a short period of time thereafter, for an hour, approximately 1 hour after consumption, the individual would have 500 nanograms per milliliter in his system, and that in order for that to be expelled from the body to get down to the levels that are consistent with the Canadian Alcohol and Drug Model Alcohol and Drug Work Rule, it would take 20 to 30 hours for the individual to be at levels where that substance is not impacting his ability to work safely. So that's the importance of knowing what kind of medications your workforce is on, and so that kind of analysis can be undertaken. Now, in terms of the balance of this decision here is what was sent back by the courts to the arbitrator to articulate was to review the rationale for upholding the disciplinary measure of discharge on the part of the arbitrator. And in this case, the arbitrator had to review a number of circumstances, such as what were the mitigating and aggravating circumstances in this matter, what kind of other case law is there on the penalties, and also reviewed if reinstatement would be available, like a substituted kind of form of discipline, and if so, what kind of conditions might coincide with that reinstatement. And linked to that, in a way, is the arbitrator had to get into the discussion of an employer's duty to accommodate, or what accommodation might look like. Now, in regards to the seriousness of the offense, which is certainly part of the analysis in terms of quantum of discipline, the arbitrator found that the griever's actions were a serious violation of reasonable employer work rules. And so the arbitrator found that the standard put in place by the employer and instituted by the project was a reasonable work rule for a legitimate purpose, that being to support the zero harm objectives of the worksite, and also to reduce the safety risk associated with substance at the workplace. So found that the rules were reasonable, they were made for a legitimate business purpose, and found that by violating those rules, that constituted a serious violation. The arbitrator also seemed to accept the project's mandate that violation of the alcohol and drug work rule was a safety absolute, and that in safety absolutes would generally constitute a termination, a discipline of termination, except in extenuating circumstances. What also clouded this file in a big way, it was the degree and length of extent of the deception on the part of the griever. And this, I think, weighed in and left an impression, if you will, on the arbitrator. The individual here, first of all, admitted to not take his medicinal marijuana for a period of 2 weeks leading up to the site access test to get onto the project. So that was to conceal the fact that he was on the medication. Then, as he was being onboarded onto the project, he refused to sign the medical information form, or fill out the medicinal the medication part of the form and he did that specifically to conceal the fact that he had a prescription for marijuana. And then in regards to the possession, he actually stashed his medicinal marijuana in a ditch by the road outside of the camp gate, because in order to conceal that he had marijuana on or about his person. So and then every single day reporting to work, the individual, because there's an ongoing and persistent obligation on the part of employees to report any medication that would impair their ability to work safely. Every single day thereafter, for the period of 4 months, he concealed by failing to report that he was on this prescription. So the griever went to great lengths to conceal and deceive, and that again left an impression on the part of the arbitrator. The arbitrator also highlighted that the fact that the occupation, by failing to disclose, it hindered the employer's ability to comply with the Occupational Health and Safety Act, which specifically states that a worker shall not be assigned work with any medically documented impairment that may endanger that worker or other workers. So by him failing to disclose, it actually worked against the employer in terms of the employer being able to comply with safety legislation in the province of Newfoundland and Labrador. And again, the deception was persistent and repetitive through every single day that he worked on his 4-month tenure. So to quickly summarize the mitigating factors, though, that the arbitrator went through, first of all, length of service was 4 months, so that was not a factor. He had a clean record. That's arguable, but he had a clean record in respect to the balance of his work performance, and the arbitrator accepted that that was a factor. This was an isolated incident. The arbitrator said this is not an isolated incident, so that's not a factor. Economic hardship, he found there was no economic hardship that would be worth mentioning or that would adjust his decision in this matter, so that's not a factor. Apology or being remorseful, the individual was not unapologetic and he was not remorseful. In fact, he still believed that he had a right to his medical marijuana throughout the entire process. He was following physician's advice. It was a factor, but doing so did not prove that marijuana is safe in a safety-sensitive work site. And also, in doing so, he wasn't actually following the advice of Health Canada, which is the 24-hour threshold. There was no extenuating circumstances, and the potential for reinstatement with conditions. The arbitrator found that the failure to disclose and the deception on the part of the griever seriously hindered reinstatement with conditions as a possibility. And prior arbitrations, the arbitrator surveyed a number of arbitrations and found general support for termination for failure to disclose and also for possession on site. The union put forward an argument that if a kind of a catch-22 argument, if you will, stating that if the griever disclosed before he was hired, he wouldn't have been hired, and if the griever disclosed while on the project, he would have been stood down. So therefore, because of that, he did nothing wrong, because in the union's mind that he had a right to his medical marijuana. And the arbitrator countered that almost in a polar opposite statement by saying, the disclosure obligation is an important part of ensuring a safe workforce. Therefore, the penalty needs to be significant enough to serve that deterrent purpose of the discipline. And the arbitrator did spend a little time discussing on how refusing to disclose the status of someone's medical prescriptions that may impact a person's ability to work safely seriously undermines the objectives of the work rule, which is an honorable one at that keeping that worker and the workers around him safe. Quantum of discipline. Well, because the union requested accommodation in the second arbitration, that the arbitrator was compelled to look at the possibility to substitute a reinstatement with conditions, which in doing so would lead the arbitrator to have to consider accommodation. So in terms of quantum of discipline, with that in mind, the arbitrator found that no back wages would be appropriate, and that the termination would be amended to a suspension without pay. Now keep in mind that the individual was terminated on August 24th, 2015, and this decision was on July 18th, 2017, with no back wages. So read between the lines on that. For all intents and purposes, the termination was kind of upheld. Certainly the individual was not going to profit from this decision, and certainly not profit from deceiving the employer in the way that he had. Now, in terms of reviewing whether or not accommodation was appropriate, the arbitrator simply stated that he did not have he did not have all the factors or the information in front of him to properly assess what kind of accommodation and what kind of return to work conditions might be appropriate for this worker. So he put that back to the parties and advised them to work through it themselves, and if they couldn't arrive at an agreement on what accommodation would look like, that he would reserve himself to answer that question if required. So this one, thank you for this case here, and just be advised that this duty to accommodate is a work in progress, and there was another case that's been heard and just recently published, so we will be publishing that one directly. And that one gets into more detail in terms of the safety risk and the science around the testing and the impairment associated with marijuana, and also gets into some further dialogue and analysis around an employer's duty to accommodate medical marijuana. So thank you for your attention to this. We hope it's useful. If you would like to subscribe, just click on the logo in the bottom corner and you'll get notification of when we submit further videos. Thank you.